Okay, abusia be makwa abasron so edeba POG Media so. Abusia yembonra eye yensem no. Finally, John Dramani Mahama released statement for the removal of a Chief Justice abusia enye asam keto akra nti no sisia no or the letter aba abontia say a Chief Justice Torkonoo sisia no Neduma na nkasa no John Dramani Mahama wasan ase say yempam no in free office or say President Mahama consult with the Council of States on 3 petitions for the removal of the Chief Justice Torkonoo. And no NHS ya project ato e screening chain. Right now no 3 petitioner amount for a file against a Chief Justice Torkonoo. President Mahama edi akwakoto a Council of State for enim say omontena say emra kwan so say yenye de yenyi Chief Justice no edi anase then right now no bibia no eshe John Dramani Mahama nsa. And whilst the process going on no John Dramani Mahama ewo ho kwan say obe suspend Chief Justice Torkonoo abusia adene de enya ayeka maame no adwuma abona enye asem keto akra yensem mremo me yanko na yankonkoti ensema ekoso letter no na ichese ya project edi ato ye screening chain answer na ebekono o ensem kan bi afahye the comment section mo like na share ma from so ensa into me enkabi POG Media so
Coming up next, President John Dramani Mahama has forwarded 3 petitions for the removal of the Chief Justice to the Council of State, marking the beginning of a constitutional process to remove the Chief Justice or otherwise. And we'll tell you exactly what the procedure is as enshrined in the Constitution and what is to be expected in the coming days. And this is one that it's not going to be the first of its kind. We've seen previous instances where the former president, Akuffo, was petitioned by ASEPA, and other groups for the removal of the then Chief Justice Ninyabwa. And now we also do know that even prior to President John Mahama becoming president, the former president Akuffo had been petitioned by Professor Kwaku to have the Chief Justice removed. But then again, we understand there's been 3 different petitions right now. That's the information we're getting. This is the detail for a statement that came through from the presidency earlier today. My colleague Dennis Baberi-Wadam is going to be joining me in a bit. But here's what we do know, that 3 petitions President Mahama has received from various persons seeking the removal of the Chief Justice. Now, the president, and this is a statement that was signed by Phyllis Akuffo, so the president has forwarded the 3 petitions to the Council of State to commence the consultation process mandated by Article 146 of the 1992 Constitution. And that is the details as we have it now, and also what the statement by the spokesperson to the president and the Minister for Government Communications, Felix Kwachu, Member of Parliament for the Ibrasibu-Kwamankese constituency, issued a statement earlier today. And here are the details as we have it. In fact, it came through just about 2 hours ago, so it's pretty fresh on the plate. Now, the information we're getting, that some 3 petitions from various persons seeking the removal of the Chief Justice, the Ladyship Justice Torkonoo. The President has forwarded the 3 petitions to the Council of State to commence the consultation process mandated by Article 146 of the 1992 Constitution of the Republic of Ghana. So that is the information we're getting right now from the presidency. And this is one that we're keeping an eye on and how things are playing out. right now here on Ghana Tonight. But let me just remind you as well that this is an issue that really the many people who have been watching how things have been playing out even after the elections and asking questions about what the way forward will be, especially in the matter of the Chief Justice. Dennis Boberwadam Esquire is my colleague. He's joining us in the studio right now. Dennis, now the details of this statement gives pointers of what is going to be happening in the coming days. But let's put it in context. What should we be expecting going forward?
Well, so now that we have been told that the president has forwarded these petitions to the Council of States to start the process of consultation, it indicates that clearly, first of all, there are some petitions before that have been sent to the president in respect of removal of the Chief Justice. Now, typically what happens when it comes to the removal of justices of the superior courts in general will be that, first of all, the president will forward that petition to the Chief Justice, who will determine whether there's a case to be heard, what we usually refer to as a prima facie case. However, when it comes to the Chief Justice herself, because a petition cannot be forwarded to herself to determine whether there's a case to be made against her, the president typically will do that in consultation with the Council of States, who constitute a committee. It is that committee which will look into the matter to see if there's a case to be heard, and then they will take it from there.
I see.
Now, that committee is supposed to be comprised of 2 Supreme Court justices and then 3 other persons who are not supposed to be members of the Council of States. They are not supposed to be lawyers, and they're not supposed to be MPs.
Right.
So together, that committee, after first determining whether there's a case to be heard, then they begin to go into the matter itself to determine the merit of it. Thereafter, they make recommendations, and then the president is bound by the recommendations of that particular, the recommendations made by members of this committee. Now, it is instructive to know that we've got to this point because when you look at the construction in the Constitution, it was not too clear what the procedure should be for the removal of the Chief Justice herself, because like I explained, it gave indication that in the case of superior courts of the justice of the superior courts, it was the case that the petition will be forwarded to the Chief Justice.
Right.
However, in the case of the Chief Justice, there seemed to be some confusion as to what the procedure should be. And that's how come the Supreme Court used the opportunity in the case of Frank Ejechum versus Attorney General to give us a clear indication as to how we should progress. So the procedure that is now used, or that will be used in this particular instance, will be that which was defined by the Supreme Court itself in the case of Frank Ejechum versus the Attorney General.
I see. Now, what I see in there is that let's dwell a bit more on the first point on what's on the screen.
Yeah.
That if there's a prima facie case, a committee.
Yes.
That is after this has been referred to the Council of State. So we are on the second stage of this process. Let's flip back to the earlier point. So the president has received the petition from these 3 individuals.
Yes, that can be implied from the letter we get from the presidency.
Perfect. So this box has been ticked.
Ticked already, yes.
Then the second point is the president has now forwarded this to the Council of State.
Yes.
To
so that
determine
means
whether
that
there's a prima facie case.
the consultation process has begun, because when you read the letter, it indicated that it is the beginning of the consultation process. What it means is that with that consultation, a committee will be set up. It is that committee which will now determine whether there's a prima facie case.
I see. And the constitution of this 3 committee, let's flip to the next. It is defined in 146.
You will find all of that in 146.
And they are not supposed to be lawyers or MPs.
They are not supposed to be lawyers. They are not supposed to be MPs. They are not supposed to be Council of State. Because mind you, it is the president in consultation with the Council of State that will form this committee.
So then the president has a discretion to choose
from
amongst all other individuals who are Ghanaians, apart from MPs, no lawyers, or members of the Council of State.
Yes, to be on this particular committee and to do the job. What is instructive is that at the end of the day, whatever recommendations that the committee would come out with, then the president would have to act by that. However, when you look at
the president chooses, that's not what I understand. So the president chooses these 3 individuals?
Yes. Together with the committee, the Council
of State.
Yes.
Okay.
But like I was saying, when you read the full complement of Article 146, you would find that along the line, when such a petition is brought against either a justice of the Superior Court or even the Chief Justice, as in this case, the President may, by a warrant, suspend the Chief Justice.
I see.
So that is also part of the law as we have it. So when you look at it closely, it is one that the President has the power to exercise. But as we stand now, we are still at the point where the President has forwarded the petitions to the Council of State for that consultation process to begin. Thereafter, then we can see what next. But what needs to be put on record and what will be the turning point for this will be whether or not this committee will make a case out of these petitions or not.
I see. And you're saying that the President still has the power to, for instance, suspend the Chief Justice while this whole process is ongoing?
Yeah, that's what the law says.
And this is it?
Yes, so that should be in, I think, 146 or 7, thereabout, okay. One of them. So if you can move to that particular provision, you'll find that the Constitution actually gives the President that power to... Okay, let's look at the 8th.
So this, I see, all proceedings...
So, yes, proceedings should be held in camera and all that. And that's the more reason why when some of these petitions come, it is very difficult for the media to be able to put the details out there.
Precisely. Because it's supposed to be held in camera. And the justice or chairman against whom the petition is made is entitled to be heard in his or her defense, in this instance, by himself or herself or by a lawyer.
Yes.
Or other expert of his choice or her choice.
It's typically going to take the shape of you being accused of a wrongdoing, and then there's supposed to be a tribunal which is going to sit on your matter. So in that respect, you'll be heard in your defense. You can either do so by yourself or by a lawyer and all that. So to go through all that process, and eventually the recommendations will be made.
I see. Now let's flip to the 7.7 because the committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. So it is the burden of this 3-member committee that would now determine the fate of the Chief Justice going forward. Either be these petitions should be dismissed or considered for that matter.
Okay, so
interesting.
So the point I was making, so when you look at 14610A, where it talks about where a petition has been referred to the committee under this article, the President may. A says that in the case of a Chief Justice, acting in accordance with the advice of the Council of State, again, by warrant signed by him, suspend the Chief Justice. Where it has to do with other justice of the Superior Court or a chairman of a regional tribunal, acting in accordance with the advice of the Judicial Council, suspend that justice or that chairman of the regional tribunal. So that can be found at in Article 14610A and B in respect of the power of the President to suspend whilst this proceeding or a petition is brought against any of these persons that we have talked about, Alfred.
I see. So that's what is on the screen now.
Yes.
Interesting. So this we can find the details of. But then again, this is not the only legal matter we're having to deal with today. Now, coming up next here on Ghana Tonight, we go straight into the matters related to that's Kwabena Dubois. That's coming up next here on Ghana Tonight. The former CEO of the National Signals Bureau, the minority in Parliament, they've raised concerns with the recent arrest of the former government officials in relation to various allegations of wrongdoing. We'll hear exactly what the concerns are and if they are really in good faith. That's the fundamental question right now. And we're going to get into information that we're getting about the plea by the lawyers of Kwabena Edujemfi to have the bail conditions varied because they're burdensome. We'll get into the details of that shortly. But the lawyers for the former Director General of the National Signals Bureau, that's Kwabena Edujemfi, Kwabena Eduboahing, I beg your pardon, that's Kwabena Eduboahing, have applied to the High Court to grant their client and his wife, Angela Boateng, bail. Now, they claim that the bail terms granted by the Economic and Organized Crime Office, EOCO, is, quote, burdensome. Now, what exactly do they mean by this? The bail application is to be moved on Friday, March 28th at the High Court. if you recall yesterday, Dr. Justice Adam Side, the Deputy Attorney General, gave us details that they are supposed to, as it were, come up with 260,000 CDs each, some sureties. So we understand that they are finding it difficult to raise that bail amount, and that is why his lawyers have come up with this particular plea to the courts, and also asking that the bail conditions be varied. We're going to get into the details of it as we have received earlier this evening, and then also get a bit more reactions to this. But even before that, the minority in Parliament, they raised concerns. In fact, the minority leader, Alexander Afenyomakin himself, had this to say about these recent developments with respect to the arrest and interrogation of former government officials in the ex-Akuffo Addo administration.
They terminate your appointment, and you have the ministers defending the actions. Since when did employment after December 7 become an irregular employment? So far, it is only one minister who has lived up to the promises of the Constitution by refusing to sack Ghanaians in his ministry. But even so, it's too early to commend him. We wait to see what he's going to do. All other agencies are sacking Ghanaians, all because they do not have NDC party cards. This is a government for NDC apparatchiks. They don't believe in the Ghanaian dream. They don't believe in the promises of the Constitution. And they do so because they have no spare to prick the size of their intent. Only partisan ambition overleaping itself and falling on the other. Shakespeare reminds us of this. This is the character of the NDC. It is their party first and nothing else. We have seen how they approach issues of accountability. Mr. Speaker, we in the minority are not against accountability. We believe in accountability, but we are against abuse of human rights. Today, all the human rights lawyers in the NDC have kept quiet. They've gone to sleep. Where are their human rights lawyers? They are human rights lawyers who are in court enforcing the rights of citizens. Where are they? Today, Ghanaian citizens are detained by investigative agencies beyond 48 hours. Ghanaian citizens have their right being abused without taking them to court.
That's Alexander Afenyomakin, the minority leader, MP for the Futu constituency. You recall that I asked this question of the Deputy Attorney General as to why this Kwabena Duboahing and his wife are still in custody. The reason being they have not been able to meet the bail conditions. That's according to the Deputy Attorney General. And rightly so, we've seen that captured in a letter from his lawyers making a plea. And Dennis has the details of this affidavit in support of this motion we're talking about. David, Dennis, what more do we know?
Well, so it's actually a process they filed in court today, and they are seeking to get bail for these two suspects. That's Kwabena Duboahing, and then the wife, Angela Ejibwateng. That's because, like you rightly said, they were granted bail by Iyoko. Unfortunately, they were not able to meet the bail conditions. Now, that would be one of the things that the lawyers would rely on to make the case for the High Court to grant them bail, to say that the bail conditions were very high, so much so that they are unable to meet. They also make the case that they think that the pronouncements by the Attorney General in yesterday's press conference were in some parts prejudicial. That's almost pronouncing them guilty even before they are heard or they are charged. They also raise concerns about the fact that they were not given the opportunity to have conference with their clients as is supposed to be, because conference with clients is supposed to be some confidential activity. But it is the case of lawyers for the suspects that at the time they went to Iyoko to have conference with them before interrogation, they were asked to have that conference on the counter, and that somebody had to listen to it. They thought that was a violation of that arrangement that they are supposed to have. So you have a motion that they have filed. We are still not sure whether, it's been filed today, so maybe in the coming days we'll see whether the Attorney General or Iyoko will also file an opposition to this particular one. But essentially, what they are seeking to do is that they are saying that they are ready to stand trial if they are given bail. They have persons of means to stand surety for them.
Okay, abusuya wene ensma ekoso ewo political highway so Chief Justice Torkonoo and Asisiano na so ayeshia enye asemketo akra. Ebeda masesa menche pene kokoti za audio no edimai aha POG Media so.